In 1999, the Supreme Court of Canada released the Gladue Decision. Its main purpose: to clarify how judges must consider the special circumstances of Aboriginal people who face the justice system. The decision is named after one young Aboriginal woman. Jamie Tanis Gladue's failed appeal resulted in a decision that may impact so many others.
What Gladue is, it's the court's best effort to recognize that protection of that integrity and that way of life and way of knowing had to be interpreted through their decision. There is an obligation that Canadians have to be sensitive to those things and to be considerate and to acknowledge, that Aboriginal people have to be recognized as a unique culture within our country.
As the CEO of Native Counselling Services of Alberta, Alan Benson is aware of the positive potential use of the Gladue Decision. The focus of NCSA is on restorative justice programs to help Aboriginal people facing Alberta's justice system. NCSA also includes the knowledge and experience of elders and cultural resource people who work in the justice system.
I want to make some offerings to you from all of us here and ask you for your help and guidance. I'll start with you, William. Oh. Hey.
Cultural protocols must be respected when information is asked for.
When we consult with the elders, and we do that regularly, we ask them for guidance around what we're doing. Lately, we've been asking for a lot of guidance around justice and traditional thinking and ways of knowing around our relationships with the law and our relationships with each other. And when hurts are committed against somebody, how do we deal with that?
In the beginning, it was supposed to be that harmony. But how can you have harmony when one party is more dominant and in their dominancy are creating all these conflicts for us? They can get more and more policemen out there, but the crime rate is just going to spring up faster and faster. There's something else there that needs to be done.
What does the Gladue Decision mean from a judicial point of view? And is it different from Aboriginal justice service providers?
The Gladue Decision was narrowly about Section 718(2)E, which is about sentencing. The Gladue principles apply whenever the liberty of an Aboriginal person is at stake.
Jonathan Rudin is the Program Director of Aboriginal Legal Services of Toronto, where the first Gladue Court is operating under its direction. He also acts as a consultant for Aboriginal justice service providers.
The Gladue principles, sort of at their heart, are that judges need more information before sentencing people. Gladue, as a decision, is not a sentencing discount case. It's not like the lawyer stands up and says, Your Honor, my client's an Aboriginal person. I know you're going to give him 9 months, but, I want the native discount. I want a third off, and he gets 6 months. I mean, it's not a sentencing discount case.
At Jamie Tanis Gladue's trial, the judge found that because she did not live on reserve, Section 718 did not apply to her case. At her appeal, it was decided that it applies to all Aboriginal people, whether they live on or off reserve.
There is the assumption that if you're an urban dwelling Aboriginal person, that traditional things shouldn't apply to you. And I'll use myself and my family as the best example. I'm a CEO of an organization. I don't look First Nations. I work in a very professional world, in a political world, but I walk both paths. And I do balance those values that are very difficult to balance, cultural values and Western values. There are a lot of Aboriginal people that live in the urban center that live that way.
The Honourable Mr. Justice Richard Marceau was appointed to Alberta's Court of Queen's Bench in 1996. He is also the Deputy Judge of the Supreme Court of the Yukon. Justice Marceau's experience gives him an understanding of the issues that bring Aboriginal people before him.
Many Aboriginals come before the courts not having had many of the privileges of non-Aboriginals in this society. And all that Parliament told us to do, and all the Gladue decision in the Supreme Court of Canada does, is say you pay special attention to the background factors. Obviously, we're talking about the big picture. We're saying that if you as a little child were unfortunately yanked away from your parents, put in a residential school, and punished for trying to speak Cree or whatever your native tongue was, that is a factor which may explain the later behavior and may also indicate how we can implement some restorative justice to, keeping in mind we've got to protect the community, but perhaps we can design a sentence that is more remedial in nature than punitive.
In 1993, the judiciary, the Crown Prosecutor, and the community at Alexis First Nation formed a committee and began working together on a restorative court process for Aboriginal offenders. West Dunfield Crown Council in Stony Plain is part of identifying the right community-based alternatives to the court.
I was always deeply troubled by the lack of options that we have in court and jail. While it's suitable for some people, dangerous people should be in jail. Most of the people I deal with are not dangerous people. They're addicted to alcohol and drugs. They are sick people. It's increasingly obvious to me that where you have addiction, you're going to have aberrant behavior. And where does it all come? Right through the courtroom door.
Since the sentencing reforms that happened in the 1990s with the criminal code, why are more Aboriginal offenders being sentenced to prison terms than non-Aboriginal offenders?
Systemic racism you often find by looking at other things and working backwards. So the big evidence of systemic racism in the criminal justice system is Aboriginal overrepresentation. And then when you start from overrepresentation and then you work back and try and figure out why does that problem occur? It's not that every Aboriginal person has been wrongfully convicted. I mean, certainly there are some. So Aboriginal people are breaking the law, but why are they so overrepresented? And that's where you start looking at issues like, do Aboriginal people get bail? If they don't get bail, do they plead guilty right away? Do they have access to lawyers who listen to them? Do judges make assumptions about who they are based on the fact that they're Aboriginal? So you look at all those things, and then you can reach a conclusion that there's a problem with systemic racism in the criminal justice system.
Every day I get scared for my sons, because as a young Aboriginal man, they're targeted by the system, police, because they know they're probably poor. They know that they're probably into drugs and alcohol. You know, that's a stigma that our young men live with. And so if they weren't targeted and they weren't looked at, maybe they'd be all right. But these are just some of the things that we talk about privately in our work. But I think it's important for people to hear it.
Well, there are more Aboriginal people going to jail because I believe we still haven't applied the philosophies, we haven't created the protocols, we haven't spent the time and effort in training people to better understand the Gladue case as the example. I think in Alberta there's still a strong thinking that legal aid takes care of the poor and legal aid takes care of the Aboriginal population. And I don't believe that's the case. And it's not a criticism of legal aid. The system, again, structures itself around need.
There are people all the time who'll say, I'd rather go to jail. I know how to go to jail. I do well in jail. I'm kind of special in jail. You know, I don't want to go and talk about my life, and I don't want to have to start to do the work that I know I'm going to need to do. I'm not ready for it yet. So there's no question. And again, the courts have recognized that. There have been court decisions that say, you know, restorative work is not easy. In fact, the court says that in Gladue. They say restorative work isn't easy. It's often harder than doing time in jail. So I think there's a recognition of that. You just have to make clear what the restorative approaches need to be.
The Gladue decision brings the principles for healing Aboriginal offenders into mainstream. Yet it is criticized as creating two levels of justice, one for Aboriginal people and one for everyone else.
We already have always looked at sentencing on an individual basis. It's no more two-tier than to say, and no more racist than to say, this fellow has cerebral palsy and he's had some brain damage from birth. And he comes before the court with quite a diminished sense of responsibility because of his brain damage. And therefore, we will try to perhaps put him in a residential situation rather than put him in a jail. It's not where he belongs. He needs care. He needs remediation. And you say to me, well, yes, but, you know, he robbed a bank, so he should get 4 years like everybody else. The fact is that 4 years is perhaps a starting point, but some bank robbers get probation and others get 8 years and 10 years in jail, depending on the seriousness of the crime and often the moral responsibility of the person and the background issues.
Linking the background factors with an Aboriginal offender's criminal behavior is an important aspect for Aboriginal justice service providers to consider. Concrete suggestions must be given for a sentence that will address the reasons why an individual is engaged in criminal activity.
Yeah, here's a good example of resourcing. This letter is to confirm that X has successfully completed our day program, May 13 and 14, called Triggers and Consequences. She's also attended AA groups on Mondays and NA groups on Wednesdays, completed a 3-day workshop at the X counseling service called The Higher Power and Healthy Humor, continues to work on her sobriety and well-being despite the obstacles that confront her, and is determined to continue her sobriety, and with solid support will be able to achieve her endeavors and goals. So. I will tell the defense lawyer, if your guy does residential treatment and agrees to a lengthy probation, AA, no alcohol, no drugs, you know, that sort of regime, and we bring them back every 2 or 3 months to see how they're doing, I won't ask for jail. And there were lots of cases where in any other court, jail would have been the only route.
We had a young person who was committed for dropping a brick off a causeway and killing a bus driver in Edmonton. And the story of the victim's family and the young offender, the young adult, went through a reconciliation process. And that, a circle. And they referred to it as an Aboriginal circle, the equivalent of an Aboriginal circle. And that circle was very successful. And in many cases across Canada, those circles are being applied to non-Aboriginal people, and it's working.
The individual facing a sentence must be aware of the healing measures they can carry out, and the service providers involved with them must be able to recognize if the person is sincere and ready.
Part of the amendments in the criminal code was a new type of sentence, a sentence called a conditional sentence. And a conditional sentence allowed a judge to say, all right, I think what I would like to do under normal circumstances is send you to jail for, let's say, 15 months. But what I'm going to do is, I'm not going to send you to jail for that period of time. You can be in the community under particular conditions, and if you follow those conditions, you won't go to jail. If you don't follow those conditions, you can go to jail for the remainder of your sentence.
We, at our level of court, are dealing a lot with the more serious offenses, and those offenses are often so serious that there cannot be much consideration for conditional sentences or non-custodial sentences. Having said that, there are many occasions when we can impose them, but these kind of sentences should be implemented and are implemented a lot more at the youth level or the young offender level, where we're dealing with first offenders that can be turned around earlier in life. To a great extent, the provincial judges can be more creative than us in considering the Gladue decision.
The elders talk about things like a wrongdoing. Somebody made a mistake. So there's the mistake that's made, and then somebody did something wrong to another person. That's another level of seriousness of behavior. And then somebody who has done something really serious, violent, murder, rape, that's because there's a serious dysfunction, a mental health problem. And so they look at all those levels of behavior, not as crime, but as behaviors. And every one of them has a fix. Some of the fixes might be pretty severe. And so we equate something more serious, like murder, to prison, where the elders might see it as, banishment or something. But all of it has a meaning about the interaction they have with the community and the relationship, and how the rest of the community has to survive based on your behavior and how that impacts on their survival. And so that's really important in how we look at behaviors in our laws today, and how we heal young people that commit crimes, right? If we don't incorporate that kind of a thinking, then we don't change behavior.
Some critics of the Gladue decision say that utilizing its principles will not reduce the crimes committed by Aboriginal offenders. Aboriginal people are overrepresented among the victims of crime, as well as being the perpetrators.
We probably do more victim consultation than any other office. It has to be part of it, because if they're not on board, I mean, it doesn't matter what the Justice Committee says. It doesn't matter what I'm prepared to do. The victim has to be taken into account. And on the reserve itself, it's less of an issue because they know, they are living the experience that promotes this kind of activity. They understand it, and they want relief, they want change, they want treatment.
I have seen many situations where the community at large didn't want that offender back in that community at all. They were, let's say the chief and council or the elders were not very happy with the kind of sentences that were meted out on the Gladue principle. And I think that there are two principles involved, and one of them is that the chief and council and the elders of Indian bands and the leaders of the Aboriginal community, the Métis, etc., should get involved in the justice system. They are often invited, but not often do they come forward and say, we want a hand in the sentencing.
There are just some things that we can't do to each other with impunity, and we shouldn't. We shouldn't allow it to happen. When I say jail should be for dangerous people, you break your wife's eye socket, or you break her arm, or you stomp on her head, and she's brain damaged, you're going to pay. That's all there is to it. And as much as I wish it didn't happen, and as much as I believe that addictions is responsible to a large degree for what you did, there are some things where there has to be a penalty, so that we all know in the community, you can't do this, you can't do it, you won't get away with it. I don't know what the answer is, and I'm not smart enough to ever know. But I know injustice when I see it, and it makes me angry. So, you know, I'm just a Crown attorney. I can only do so much. But what I can do is important because it involves the delineation of jail or no jail, treatment or no treatment.
The approach used in West Dunfield's office seems to be working.
We did a count over an 18-month period on all of our restorative sentences. And our success rate statistically over that 18 months was 78% success, okay? Now I count success as compliance in every respect. You know, of the remaining percentage, there were cases where there were significant changes and improvements, but slips and problems and, you know, but very few of those And this is one of the only offices in Canada that actually will apply to revoke a suspended sentence.
In Jonathan Rudin's experience, there may be a different reality in courtrooms across Canada.
In most courts across the country, it's sort of business as usual. And if it's business as usual, the result will be more and more Aboriginal people going to jail. I know that in the courts that we work with in Toronto and in the Toronto area, when we do a Gladue report, when we make suggestions, possible recommendations to the judges for options, judges are very quick to take those up. They're very enthusiastic about those sorts of things. Crown attorneys change their position. They start by saying, oh, we have to send this person to jail. They read the Gladue report, they read about the person, they read about the options, and they go, no, this is a better option. Let's not send them to jail. So on a micro level, it's clear that Gladue works. It's clear to me that when the principles are applied, they make a difference.
Out of experience, I believe the answers are in our community and in our culture. They're there. I think that we have the capacity to solve the problems. The problem is I don't know that the will is there amongst our own people as well as government. You know, that we look to the government to solve our problem, to resource our problem. We have to show some real leadership. And that means that we need to make a very strong commitment at our community levels that things are going to change. There's going to be zero tolerance for drug trafficking in our communities, zero tolerance for gang violence in our communities. And we're going to enforce it by our own bylaws at the First Nations level. We're going to enforce it by working closely with the judicial system and the police. We're going to send a clear message to our kids that as leaders we don't accept this behavior. That we have to start there first.
What happened there now? You got a little bit too hard. With the top? The top, yeah. Back it up. Slack it off a little bit, eh? Yeah. Grab this side, Sam.
We need to start promoting our own worldview. It's not to say that to have biases against the Western system, but rather to understand why things are the way they are. Because that's where it came from. And now we're here. So what can we do to correct that, you know? The damage has been done. So let's look at that. What do we learn from that damage? How can we get beyond that?
Jamie Tanis Gladue's appeal led to a Supreme Court decision in her name only.
Nothing changed for her. What we do in this country and many countries that have a legal system like ours is we elevate the decision, the name of the decision becomes a principle. So we now always talk about Gladue. There are other cases that we always talk about, lawyers always talk about, and they're always the name of the client. But what happens to those clients, no one really knows. The case takes a meaning well beyond what it has to the individual. And Gladue is a perfect example. It's a decision that had little impact on Jamie Gladue because her sentence was done. But it had a huge impact, or potentially has a huge impact, on Aboriginal people who are sentenced since that decision.
The Gladue decision may have far-reaching influence in other areas where Aboriginal people are involved in legal hearings. What does it mean for an Aboriginal offender's spirit to be mended from an Aboriginal perspective? The only people who can make it real are those who are working in the criminal justice system and the Aboriginal people who are facing it.